All right, members, welcome to Civil Justice Subcommittee for February 18, 2026. If you'll sign in and signify that you are present. If everybody will sign in. Representative Garrett. All right, Mr. Clerk, take the roll.
Mr. Chairman, you have 7 members present. You have a quorum.
All right, members, the clerk has detected a quorum. Any personal orders? Seeing none, we will jump right into the calendar. Item number 2, House Bill 1915 without objection be rolled 2 weeks. That brings us to item number 1, House Bill 1791 by Chairman Zachary. We have a motion and a second. Chairman, you are actually Deputy Speaker.
Thank you, Mr. Chairman. Good to be with you, gentlemen, ladies and gentlemen, this afternoon. Members, I'm carrying this on behalf of our Attorney General. A fairly simple bill. It simply aligns state code with federal code, allowing the state to appeal. I'm going to do my best to say this correctly, an interlocutory order. Thank you very much, Counselor, to the Tennessee Court of Appeals. And it lists out what those include. That includes the reason, the interlocutory trial court orders include granting or refusing to dissolve an injunction against state officials, denying sovereign immunity of a state official or denying qualified immunity of a state official, and then denying the state's motion to dismiss when the challenges are the constitutionality of state law or constitutionality of legality of an executive order, administrative rule, or other governmental action. Again, it's just aligning us with state law. I'll be glad to answer any questions.
Very good presentation. Members, we got any questions? And Representative Johnson, you're recognized.
Thank you, Mr. Chairman. So what appears to be happening is this legislation's a special state lever that only the state attorney general can pull to delay a case indefinitely and grind down any citizen who dares to challenge the constitutionality of state laws. This bill would give the attorney general special automatic appeal rights only available to the state. Under this bill, a higher court would be forced to accept an AG appeal to dismiss a case on procedural grounds. If the AG wins, the case is dismissed. The state wins. If the AG loses the appeal, the AG can appeal again and again and again. And this is before there's ever any discovery or any discussion of the case itself. You know, it's only billionaires who are challenging the state will be able to afford justice under this. It's literally creating a 2-tier justice system where the AG and state can do one thing, but everybody else has got to go through the regular process. So it's kind of like rigging the courts. The attorney general already has the right to appeal these procedural grounds to a higher court, but it requires approval from the courts. Why are we removing that approval from the courts for this to happen? The bill would rig the process by removing judicial discretion on the state's appeals to dismiss, and citizens and businesses would not have this right. That's what I'm saying about the 2-tier system that this is creating. There's a problem under equal protection, it would seem, under separation of powers. It violates judicial independence. So I guess my question is, this bill is working hard to kill lawsuits against the state on procedural grounds. But what about on the merits of the law? They don't even get to the merits of the law. And to make that argument, it's just constant appeal, and tying a citizen or a smaller business up in court for years. Is that not a concern of folks, that the 2-tier justice system that this creates?
And members, you're welcome to go back and forth. Just keep it civil.
Yeah, thank you, Mr. Chairman. Most of those talking points that you reference have nothing to do with this legislation. Again, this is already in federal code. We're aligning state code with federal code, and it only applies to granting or refusing an injunction against the state, denying sovereign immunity or qualified immunity, and denying a state's motion regarding constitutionality. The appeal has to be approved, and if it is appealed, then that's when it takes the next step up to the state. Make sure I say this correctly. Up to the state court of appeals.
But it allows the appeal before the law and the discussion of what's at stake is even discussed. It's a continual state of appeals. This is not something that's already there. It's already there to have a court approval, but we're talking about before that ever happens, before anything's ever argued, before there's discovery.
Thank you, Mr. Chairman. This appeal happens once the process has begun. And again, the appeal has to be the appeal has to be heard, or the appeal has to be heard by the Tennessee Court of Appeals, and then that appeal can be denied. Many times in these lower courts, they simply don't have the expertise to handle some of the challenges that are presented. And so it gives the state the ability to streamline the process and not waste taxpayer dollars by dragging out a suit that can continue on and on and on when they can take an additional step appeal. And then the appeals court can look at that and determine if the process continues forward or if their appeal is granted. And again, we're aligning this with federal code. This is not groundbreaking legislation.
Well, it's not groundbreaking, but it's creating a two-tier system. We're doing something for the AG that we're not doing for any other entity in this state. And I don't think that's a good idea. I think that's problematic.
And y'all can go back and forth.
Mr. Chairman, we have to do it for the AG. He is the one that is defending the state of Tennessee if Tennessee gets sued. So of course this is going to apply to the AG because him and the Solicitor General, they're the ones that are going to be defending Tennessee if there is a suit. So of course this applies to them.
Do you understand that the appeal can happen before anything is ever rolled out in court? That is the problem. Why not let the courts decide after you've made your case and then see about it? But this is an appeal before anything's been done in court.
This appeal only applies to an interlocutory order from the court. So this has to be in place. Then once that is in place, I'm correct in saying that, once that is in place, then that's when the appeal can be requested. And then that's when it goes to the Tennessee Court of Appeals. And then based on those three criteria, then the Tennessee Court of Appeals can make the decision if that appeal is upheld or not.
And it can set up an
Representative
appeal.
Johnson, and just to clarify things, we do have somebody from the AG's office, if you'd like to bring them up to clarify some of this too.
I'm sure that this is something the AG wants. I'm just not sure. And they can make, I don't need them to make their case. I have a great understanding of what this does, and it creates a two-tier system. And that's just a fact.
Mr. Chairman, I don't think that's necessary. I appreciate the comments.
Okay.
Thanks.
Any follow-up? All right, Representative Garrett.
Thank you, Mr. Chairman. And Speaker Zachary, thank you for bringing this piece of legislation. Let me see if I can kind of narrow this down a little bit of what I think you're attempting to do. For one, this is in very narrow circumstances. We're applying a law that's been challenged, either facially or in practice. Mostly they're facially. So there's no actions that takes place. It's literally the court reading the words that we pass, and then there's litigation on the words. So there's no merits. They're interpreting the statutes. They're interpreting what we pass. And then if that judge particularly gets it wrong, or at least we as the state gets it wrong, then there's that interlocutory appeal that can take place. And in this sense, you're just making automatically when there's an injunction brought down by that court because it's a state law that we're not sure what to do. And so we need the Court of Appeals, or in possibly some cases the Supreme Court, to weigh in to make sure we know whether or not this statute can be enforced, if it applies to our police, if it applies to cities, if it applies to counties, if it applies to the AG's office. What are we supposed to do? So we need to make sure we get that to the judge that can look at the facts that was right there in front of them. Typically, there's no litigation. There's no discovery process. So there's absolutely no two-tiered ways that we're giving one person an avenue to challenge a statute, and we're giving the state a much better way. That's not what we're talking about. This is a decision made based upon language that's in front of the judge in a very narrow circumstances, so we can make sure as a state that that particular piece of legislation can be enforced. Is that kind of what this piece of legislation is trying to address?
Yeah, we'll go back and
Mr.
forth.
Chairman, thank you. Counselor, yes, sir. Thank
Okay.
you. That is.
Thank you. Just want to make sure we're clear on that. Thank you very much.
All right, Representative Travis and then Representative Johnson.
One more question. For legal.
All
I got a
right,
question for legal.
you've not called it yet, but. Okay. Do we have any objections on the question? We've-
What are you afraid of?
We got objections, so we're voting on the question. All those in favor of a question on the bill signify by voting aye. Opposed, no. The ayes prevail. All right, we're voting to send House Bill 1791 to full judiciary. If you wish to send it to full judiciary, signify by voting aye. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 1 no.
The ayes prevail, full judiciary.
Thank you, Mr. Chairman and Committee.
Thank you. Next up, item number 3, House Bill 2037 by Representative Halsey. Representative Halsey, do I have a motion? We got a motion. Do I have a second? We got a second. You're recognized on House Bill 2037, and I do show an amendment.
There is an amendment, and thank you, Chairman, and thank you, Committee. I have amendment number 013339 that I need you to put on the bill.
That's what I show. Everybody in favor of putting 1333, and we got a motion and a second. Everybody in favor of putting 13339 on House Bill 2037, signify by saying aye. Opposed, no. The amendment's been added, and if you'll just give us a brief description, and we've got 2 people that wishes to testify, and we'll go to
Okay,
session, then we'll ask questions.
okay, thank you. This amendment actually just says that a condemner of property using eminent domain is responsible for the relocation of people who've lost their property up to a radius of 50 miles. That's what the amendment says.
Okay, so the amendments on the bill, is that what the bill does also? or-
No, sir. The bill in itself is called a Tennessee Just Compensation for Property Owners Act. And it does 5 things. If an airport authority uses eminent domain to take people's property, this does 5 things. It makes the condemner pay damages based on the value of real property at a ratio of 1.5. In other words, if your property's worth $200,000, they will award you damages of $300,000. The second thing it does, it pays damages. The condemner pays the cost of estimates for the relocation. If you're going to have to move, of course you would, of what it's going to cost to move you. The condemner will pay the damages based on lost wages if it's a business, and a judge or a jury will determine that. And the fourth thing it does, the condemner pays damages for increased interest expense for a residential or business loan, and it requires at least 3 financial institutions to give estimates of what that would be. And the fifth thing it does is the condemner pays attorney's fees if the property is not relocated or taken, and if it can't be, or if the condemner bows out, they pay a reasonable attorney's fees. And that's the 5 things the bill does.
Very good. We'll go out of session here from David Seal first. So without objection, we'll be out of session. Mr. Seal, if you'll come up and have a seat, if you'll tell us who you are, and you'll have 3 minutes, and we'll start timing just as soon as you tell us who you are.
Thank you, Chairman. I'm David Seal. I'm speaking as an individual in support of House Bill 2037. When airport authorities forcefully take property from landowners, that property can then be leased out to private businesses for private gain. Such a taking requires the property owner yield all of their future financial gains in that property. The private businesses that lease the taken property can profit from it indefinitely. That's one of the reasons this legislation is so important. A few days ago, I met with the airport authorities who claimed that eminent domain has not been used on property owners in recent memories. I think they quoted about 43 years. There's a reason for that. Airport authorities hold the ultimate power of eminent domain over property owners. That's a one-sided, unfair advantage. The law is set up for airports to ultimately win, regardless of how much a property owner spends on attorney's fees. Of course, they can claim that property owners voluntarily sell their property. The genesis of this bill is from a meeting that I had with Blount County property owners in April of 2025. In that meeting, in the shadow of McGee-Tyson Airport, we made a list of damages that property owners would suffer from a forced taking. Those damages are addressed by this bill in great detail. Finally, we have a duty as a state to protect property owners from financial damage, especially in cases where the property is taken by force and then used to benefit private business. As you know, all the airports operate from private enterprise. The least we can do is make sure they get a decent price for being uprooted from their homes and businesses and having to move. We're not stopping the use of eminent domain. We know airports have to be built and expanded. Instead, we're trying to give property owners a more even playing field from which to negotiate. This is not a bill that defines what eminent domain is. That was settled years ago. This is a compensation bill. Tennessee needs to set a standard for the nation in compensating property owners for takings that will ultimately be used by private companies for private gain. And with that, I pray that you find favor with the bill, and I'll be happy to address any questions.
Thank you, Mr. Seal. Any questions for the witness? All right. We appreciate you being here. Thank you.
Thank you, Chairman.
Next up is Cameron Snow. Mr. Snow, if you'll just tell us who you are, we'll have 3 minutes and you're welcome to begin.
Awesome. Thank you, Chairman and committee, for allowing me to speak in front of you. I'm Cameron Snow. I'm the legislative liaison for the Tennessee Department of Economic and Community Development. The department has concerns over this bill, as we think the intention of not allowing private uses of eminent domain is duplicative under current law. Under TCA 2917-102, concerning eminent domain, the law states that government entities or entities the government delegates have the right to exercise eminent domain as long as the property has been taken for legitimate public use. Further in that code, it says public use does not include private use or benefit or indirect public benefits resulting from private economic development and private commercial enterprise. This code language was passed after Kelo versus New London, which was mentioned in the bill in 2006 to restrict qualified uses of eminent domain land in Tennessee. The department supports current Tennessee statute that no land taken by an eminent domain can be used for private use. In addition, the department views commercial airports as critical economic development growth drivers that create thousands of jobs and assist our state in attracting new businesses to Tennessee. We believe setting a higher compensation rate for eminent domain property could cause lengthy delays in the future and increase prices on travelers to pay for critical airport expansion projects that may be needed to service international markets that would further generate FDI investment in the state. I will note eminent domain has not been used in Tennessee by airport authorities in more than 40 years, and the department is not aware of any plans for airport authorities to use eminent domain in the future. The department urges the committee members to keep airport authorities in current state and federal statutes concerning eminent domain.
Thank you, Mr. Snow. Any questions for the witness? And Chairman Farmer, you're working us.
Yes, a couple of questions just based off just what you said. So you cited current code section that says, well, I heard it, it said that if an airport authority acquires property, then it has to be used for legitimate public use. Is that how that read?
Yes, sir.
Okay.
Exactly. And in the code, Tennessee Code 423116, airport authorities are public and government bodies acting as agencies and instrumentalities of creating and participating municipalities that acquire, operating, and financing of airports and related facilities, such as airport authorities, are for the public and governmental purpose in the matters of public necessity.
Okay. So how does federal law coincide with state law in this situation? I know the federal government, the FAA, we just recently had some work done at the airport, the Gatlinburg Pigeon Forge Airport, and they were very strict on what we could and couldn't do, even though the airport belongs to the cities of Gatlinburg and Pigeon Forge. So the airport's owned by the municipalities, as I understand it.
but the FAA, the federal government, regulates that airport. And as I also understand it, before the municipalities can do anything, they have to ask permission from the federal government. So how does federal law, does it have anything to do with the process of acquiring properties for runways or things like that? Can you talk a little about that?
I can't speak to that specifically. I know you're right. They have to go through the FAA, especially if the federal funding is involved for necessary critical infrastructure projects for an airport authority. But I can get back to you. I really defer to airport authorities to speak on that matter.
Okay. And do you know if, for example, the McGee-Tyson Airport, is it owned by the city of Alcoa, or is it, who owns the McGee-Tyson Airport?
That I'm not sure.
Okay. Because we're talking about airport authorities, but just back to my example, if the Gatlinburg Pigeon Forge Airport wanted to do something, it would be my understanding that it would be the municipalities of Pigeon Forge and Gatlinburg that then would be acquiring the properties. So then again, my question is, does the eminent domain statute govern municipalities currently from acquiring properties and allowing for private individual gain? Or does it fall under the same statute that an airport authority would?
To my knowledge, it falls under that same statute.
Okay. That's all the questions I have. Thank you.
Thank you. Any other members? All right, seeing none, we appreciate your testimony and for being here. Thank you.
Thank you, Chairman. Thank you.
Without
Thank you.
objection, we'll go back in session. Representative Travis, you're recognized.
Thank you, Mr. Chairman. Just because the other party was not able to make it today, I make a motion that we move this to the next available calendar.
Okay, proper motion, proper second. Okay, that'll be in 2 weeks. We won't be meeting next week due to budget hearings. So without objection, we'll roll this to the next available calendar. Would you like to?
I
Follow
just
up?
want to make one explanation because I'm worried that it won't come up again.
Oh, as long
If
as
that's all right.
yeah, it'll be on the next available calendar, which will
all
be in
right.
2 weeks.
All right.
All right, without objection, next available calendar.
Thank you, Mr. Chairman. Thank you, committee.
Thank you. All right, next up, item number 4, House Bill 2041 by Representative Parkinson. We got a motion. Do we have a second? We got a second. And Representative Parkinson, I show an amendment.
Yes, sir. We do have an amendment, and thank you, Mr. Chair and committee. 013429, is that what you have?
That's what I have. Any objection to putting 013429 on House Bill 2041? All those in favor signify by saying aye. Opposed, no. The ayes prevail. And you are recognized on House Bill 2041 as amended.
Thank you, Mr. Chairman and members. There was a private server in Memphis who does evictions and set outs. When she would do the set outs, removing the evicted person's belongings from the property to the curb, she would go live on social media. Thousands would watch, sometimes hundreds of thousands, sometimes millions. They would comment, they would like, they would share. Each eviction would go viral. I personally watched 2 of these evictions on live stream. The first one involved a woman who was clearly experiencing emotional or mental challenges during the live stream. She wasn't naked, but she still had on her clothes from sleeping. For nearly an hour, hundreds of thousands of people watched her in visible mental distress. You could hear the process server herself and some of the men working for her that were removing the furniture antagonizing this woman on the live stream while she was in emotional distress. You may ask yourself, why would they do that? Because this creates more drama. This creates more views, more shares, more comments, more followers. The live stream went viral, and as the views go up, so do the checks written by the social media companies to the person who is actually doing the live streaming. This hundreds of thousands of people watched, they liked, they shared, they commented. The second video was along the same lines, except this time, the woman being evicted was an 84-year-old woman. She was living there by herself, and you could see her on the camera pleading her case while her belongings were being taken to the street. And again, you can hear the antagonizing going on by the guys that were moving the furniture and the lady that was live streaming. And you can see her on her camera pleading her case while her belongings were being put out again. Hundreds of thousands of people were watching, liking, sharing, commenting. In these videos, everything is captured. There was zero regard for privacy. And then you read the comments. People were asking for the address. Some said they wanted to come see the house because they were looking for a place to stay. Others were openly discussing pulling up and loading their vehicles with the latest furniture and the valuables that were being placed at the curb. The private processor put the address out there on the live stream multiple times. Think about that. And then to add insult to injury in this case, it was deemed an erroneous eviction. Real-time broadcasting, real-time address, real-time property exposure. When these live streams happen, there's zero regard for what's being captured. Sometimes the streamers can capture medical equipment, prescriptions, valuables, and even children. Now, I want you to think about this. What if this was your grandmother, your mother, your daughter, or someone you know? None of us would want that moment to be live streamed for entertainment purposes and for the world to consume. This is why I brought this legislation. And what this legislation does, let me tell you what it does not do first. It actually does not stop anyone from live streaming. But what it does is it directs who, that private processor only, who they can live stream to. So they can still live stream, they can record, but in the case of live streaming, they are going to live stream to the owners of the property, management companies of the property owners, attorneys, or whoever hired them, but is not to go out to the general public during this process. And keep in mind, this is only for private process servers, not for your sheriff's department or any of that also. Lastly, I want to say we worked closely with the Tennessee Apartment Association in crafting this legislation, made sure that they did not suffer any damage from someone that they hired doing eviction set-outs, and that would be sued, and then they would be liable for it also. So we made sure we crafted this legislation very narrowly to specifically prevent what was going on with those live streams.
Very good description. First up for questions is Representative Johnson.
Yes, thank you, Mr. Chairman. Even the live stream to certain people is a tad bit, can they just do, I mean, I would think maybe just recording and then giving it to those people. I certainly understand recording for records or safety or whatever, but any live stream makes me nervous. But it does allow for just live streaming to specific people.
And y'all can go back and forth.
Thank you, Mr. Chair. Yes, it does. It doesn't stop you from recording or live streaming, period. It just simply says you have to be live streaming for the purpose that you're there, right? Yeah. And the people that need that information, that should have that information, are the people that get it.
Okay. I would prefer to do no live streaming at all, but
yeah, well,
they do what they're supposed to do.
Careful there. And you know, and remember, we're still, even though these individuals are probably in one of the most traumatic moments of their lives. I've been there before. I've been there and know how it feels, the uncertainty and you know how highly emotional it can be to be getting evicted. We still don't want to make them secondary victims of possible exploitation, criminal activities, and so on and so forth. And that's what this legislation is doing also.
Thank you.
Thank you. I don't show any other questions, but I'd like the sponsor just to explain the enforcement and penalties of the bill.
Yes, thank you. It creates a cause of action directly to the person that's live streaming only. And if a judge sees fit, they can award them up to $25,000.
Very good. We're voting. If you'd like to send House Bill 2041 as amended to Judiciary full, signify by voting aye. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 0 noes.
The ayes prevail. Full Judiciary. Congratulations.
Thank you, Mr. Chairman, and
As
thank you so
amended.
much, committee. Thank you so much.
Thank you. Next up is item number 5, House Bill 948. We have a motion. Do we have a second? We have a second. And Representative Brooks, you are recognized, and I do show an amendment.
Yes. Thank you.
Would you read your code off, and I'll check it off
Yeah,
up here?
013448.
Very good. That's what I show. Members, do we have a motion and a second on the amendment? We got a motion, and I need a second on the amendment. We got a second, and Representative Brooks, you're recognized. And just to clarify, this was gen subbed in the Senate, and we have a special calendar for that, but you got it out of the Senate onto a regular calendar, so you're recognized on your bill.
Thank you so much.
We've already added the amendment. Oh, I'm sorry, we did not add the amendment. All those in favor of adding 013448 to House Bill 948 signify by saying aye. Opposed, no. The amendment's added. And you're recognized.
Thank you, Chairman. As a survivor of domestic violence, I bring House Bill 948. Right now, there are no measures in place to make sure that firearms are being dispossessed. The bill will require individuals convicted of domestic violence, domestic assault, or placed under an order of protection to dispossess their firearms to law enforcement within 48 hours and provide proof to the court within 3 business days. This is about closing the gap between court order and real safety. This bill ensures timely dispossession within 48 hours of law enforcement, a receipt from law enforcement at the time of dispossession. Proof is filed within the court within 3 business days. This bill protects survivors. It holds abusers accountable. It equips the court to enforce the law with real consequences. I urge you to support House Bill 948 for the safety of Tennesseans, for the peace of families, for the public welfare of our state. I respectfully ask for your support and favorable vote of House Bill 948.
Thank you. Members, any questions for the sponsor? Chairman Todd.
Thank you, Mr. Chairman. One question I have here is for these situations, are folks convicted of domestic violence? Is this only misdemeanor or is this a felony as well? First of
I
all,
think it's a misdemeanor. I would think it's just a misdemeanor.
And y'all are welcome to go
Is
back
it-
and forth. I'm sorry.
Oh, I'm sorry.
it is misdemeanor?
Yeah.
Okay. And are folks convicted of misdemeanor domestic assault prevented from possessing a firearm now?
Not until, so this bill simply enforces the process is timely, accountable, and documented. No, it's not.
Okay. I'm thinking it is. Thinking a
That
person
we're-
convicted of domestic assault is prevented.
They're
Prohibited.
prevented until the judge, this is the judge's decision. Whatever decision the judge's, this bill is not about taking their rights or anything like that. It's just at that time when the judge, it's not about taking your rights away.
Well, we might get that answer in another question or going out of session or something in a little bit, but
Okay.
one concern I have is, well, I have several concerns with this. Providing, forcing someone to turn over their firearms to law enforcement, I have a big problem with. Number one, you don't know how they're going to be taken care of. There's no guarantee that those firearms are going to be maintained in good condition while they're in somebody else's possession, especially law enforcement. So that's a concern if you're going to get them back eventually. And then certainly law enforcement is going to be logging those in.
Right.
and have a registration of those firearms, which the Supreme Court says we cannot have a registry of firearms in this country. So that is a concern as well. So that I've got a few issues with this.
Yeah, my bill is not, okay, this is after the judge makes his decision. My bill is not, we're not taking guns. We're just making sure that when they're taken, right, by the judge, not by me, not by my bill, that it is registered, that the process is, that there's some kind of monitoring. When the judge say to that offender that we're going to take your guns for this period of time, there's nothing in place to show, well, they did turn their guns in. There's nothing in place to monitor. There's no one and there's nothing that monitors that situation.
Okay. Mr. Chairman, would you mind if we go on a session and ask legal exactly what we're doing here?
All right, without objection, we'll go out of session. And legal, you're recognized.
Michelle Fogarty, Legal Services. Could you repeat the question, please?
So I guess two questions. First one was someone that's convicted of misdemeanor domestic assault, if that's what this bill is dealing with, are they currently, under current law, prohibited from possessing a firearm? And then secondly, if that's the case, in this bill, is it setting up a system to where the judge would be forced to have that person convicted dispossess of their firearms to a law enforcement agency?
Yes, under current law, someone who's been convicted of the misdemeanor crime of domestic violence is a prohibited possessor of firearms. The bill amends the sections that deal with an order of protection and also with a conviction for the offense of domestic assault. And for both of those instances, it requires the dispossession to be, requires the person to dispossess by surrendering their firearms to a law enforcement agency. Under current law, they are just required to dispossess by any lawful means. This
Okay.
makes it specific that they have to dispossess to a law enforcement agency.
Okay, thank you. So would be safe to say, to more or less summarize what you just said, current law already covers this. They're able to, they are forced to dispossess their firearms, but not necessarily to law enforcement. This bill specifies it's only to law enforcement.
Correct.
Okay, thank you. Thank you, Mr. Chairman.
Thank you. And just to clarify with legal, there's nothing in the statute that prevents them to give the weapon to a law enforcement officer currently if they wanted to.
The statute uses the language, they must dispossess by any lawful means, such as transferring possession to a third party who's not prohibited from possessing firearms.
And a third party could be considered a law enforcement officer.
Yes.
Thank you. Any other questions for legal? And Representative Johnson, you recognize?
Yes, so it sounds like maybe in that dispossession, it says you can dispossess to law enforcement, but how is the reporting? Is reporting required? Because it sounds like this adds an additional way to report to make sure that it's done and done correctly. And then, to my colleagues, I mean, you want to make sure you get it back. So if there's a report, if there's, stuff in place, that it would make it more sure.
Under current law, the person who's the subject of the order of protection, who is required to lawfully dispossess, they are instructed to complete and return an affidavit of firearms dispossession. They are supposed to complete that provides the information of how they dispossessed, and then they are to return that to the court within 48 hours.
Thank you.
Thank you. Without objection, we'll go back in session. All right, Chairman Todd, you recognize.
Thank you, Mr. Chairman. And I think we already have this in place, it seems like, and this would be forcing someone to dispossess and, again, create a registry, because they're going to have an inventory of those weapons. There's going to be no guarantee they're going to be taken care of under this bill. Whereas now a person can choose who is going to get those firearms and whether, and trust that they're going to be taken care of, and not some government entity holding that list of serial numbers and descriptions. So for that reason, I would be opposed to this bill, but I certainly understand the intent and don't disagree with the intent because I think that's what's already in law, that the intent is there to get those weapons away from them so that they're not committing a more dangerous crime in the future of domestic assault. So I thank you for the intent, but I just have those concerns about it. Thank you, Mr. Chairman.
Thank you. And Chairman Farmer, you're next.
And also, we currently have documents in place when, at least in the 4th Judicial District, if someone pleads to a domestic assault, we have dispossession forms, and you have to fill that out, and you have to indicate whether you have firearms or not. On the back page, it has a place where you have to put the serial number and the make and model of your firearms, and you have to sign that in front of a notary as well. So we have those in place. I don't know if they're using them in West Tennessee or not, but if they're not, they're supposed to be doing that already. So we have that. The form is in place. The only thing we don't provide for is any lawful dispossession, just as Ms. Fogarty had said. But you know, the idea too, you're kind of looking at basically just seizing someone's property too when it comes to not being able to give their firearms to maybe a brother or sister, an aunt or uncle. Certainly, if they're convicted of a domestic assault under state law and federal law, you can't possess a firearm. So you're basically like a felon with that regards. It's only misdemeanor in the state of Tennessee that you lose your right to a firearm under. So with that said, I think we're doing most of what you want to do already. The only difference is requiring people to give their property to the government as opposed to a relative. So that's my 2 cents. Just want to kind of let you know we're already using those forms. So thank you, Mr. Chairman.
Thank you. And Representative Johnson, you're next.
Thank you. It's interesting to hear my colleagues' distrust of the police and law enforcement, but I would trust that. I think what's important to note here and what is so important is we are typically number one or in the top 3 of states where women are killed by domestic partners, and that we should be doing absolutely everything we can to get to the bottom of that list. And so I appreciate your legislation, and I appreciate that attempt to try and do something. I mean, we heard an absolute horror story earlier in committee, and this bill would be in a direct way going to combat some of that. And so I support your bill, and I appreciate you bringing it because I think we should be embarrassed and ashamed that we're not doing more in this state to protect women.
Thank you. Representative Brooks, you have any follow-up?
This bill, you know, when I wrote or created this bill, it was not about taking firearms. It shouldn't matter my bill is about monitoring, because a lot of what's happening, even though that we have all this in place, it's not happening. Like, no one is monitoring if these guns, these firearms are being
Well, we appreciate you being here. I was looking over the physical note, and here's a big issue for me that I've got with it. It says, therefore, estimated that at least 4,740 persons each year will be required to dispose one or more firearms to a law enforcement officer. Working 14 years in law enforcement, one of the big problems that we run into is room and evidence collection side, and they don't have storage for the things they seize right now and put into evidence, and that's just my issue with it. But I do appreciate everything you're doing and the difference that you're making here, and we'll entertain Representative Johnson's comments, and then we'll vote.
I struggle with concern of the cost of storage and the cost of women's lives. Sometimes it's important that we spend a few extra dollars for a few more storage, for a bit more storage space.
Thank you. Nobody else is on the list, members. We're voting. If you wish to send House Bill 948 to full judiciary, signify by voting aye. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 1 aye, 7 noes.
The bill fails. Sorry, Representative Brooks. All right, item number 6, House Bill 1968 by Chairman Farmer. We got a motion and a second. I do not show an amendment.
Yeah, it shouldn't have. Members, this bill simply allows for the state of Tennessee to accept, I believe, right at $2.6 million from 3 different entities to go into our opioid abatement fund that we created several years ago. I believe we've already collected around $460 million into that fund that's been dispersed to the counties and municipalities across the state of Tennessee. So this is just allowing for us to accept settlement dollars from 3 different corporations. Thank you.
Very good. Any questions? Seeing none, we're voting. If you wish to send House Bill 1968 to full judiciary, signify by voting aye. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 8 ayes, 0 noes.
The ayes prevail. Full judiciary. Congratulations. Next up, item number 7, House Bill 2174. Do I have a motion? Do I have a motion? We got a motion. Do I have a second? We got a second. Chairman Travis, you're recognized.
Thank you, Mr. Chairman. House Bill 2174 is brought to me by a judge in my district. About 7 years ago, we had a judge that was shot outside the courthouse after a divorce hearing. So, these judges that we have are in danger every day being out there. And this bill amends that our judges will be able to carry a firearm with proper certification, not only when they're proceeding a trial, but during the courthouse at the same time. So that's what the bill will do. We will probably bring an amendment in full to sort of mirror the DAs that we have now lined up. But that's what this bill will do, is protect our judges.
Very good description. Representative Johnson, you're recognized.
Thank you, Mr. Chair. So what are the requirements for that judge? It says that requirements must meet the requirements for enhanced carry permit, right?
Yes, enhanced handgun permit, but it may be more than that. Maybe a post permit at the next time. At the amendment that comes in, we're going to look at that.
Okay, because that's a little bit of my concern. It's not like they're like law enforcement, constant training through the years. And then also it might have been a few years ago that they had that training. And then, it says after retirement, a lot of times judges are up there when they retire. So just making sure everybody's good. So that's just, I support the idea, but I'm just a little concerned about what that means. So.
Okay, Chairman Farmer, you're going to be recognized, but just keep in mind, the sponsors want to put an amendment on this, so we need to decide if we're going to do this by rolling it, or are we going to pass it into full judiciary? So you're recognized.
I was just going to ask if we could go out of session. I was going to ask Ms. Fogarty just a couple things about the requirements that our district attorneys' requirements, because they're allowed to carry right now. They have to go through post-certification and certain things. And I believe the idea behind this bill, I don't want to speak for Chairman Travis, but is to mirror what the requirements are for our assistant district attorneys and elected district attorneys across the state, to allow for the judges to carry as well. So my question is, how's it lining up right now? Are we where we need to be, or with regards to the language of this bill to mirror what the DAs do? Because I think that's where we need to be.
Members, let's go out of session and hear from legal.
Michelle Fogarty, Legal Services. As it's currently written, it does not mirror the requirements of an assistant district attorney.
Okay.
As it's currently written, it does not mirror the requirements for assistant district attorneys.
Okay.
Do
Yeah, would you let us know what those requirements are?
Sure.
What they have to.
So they currently have to successfully complete firearms training in accordance with post-certification, which shall include at a minimum 40 hours of initial training and 8 hours of annual in-service training in firearms qualification administered by a post-certified firearms training program.
Okay. That answers my question. That answers my
Members,
question.
any
Thank you,
more
sir.
questions for legal? Seeing none, we'll go back in session. Chairman Farmer, any follow-up?
Oh, no, Mr. Chairman. Thank you.
Okay, so do I have a motion? Do you want to wait and add the amendment in 2 weeks, or do you want to pass it to full?
Yes, roll it for 2 weeks would be great with me.
Great. Without objection, roll 2 weeks. All right, members, that's the end of the calendar. Thank you for another successful meeting of the Criminal Justice or Civil Justice Subcommittee. Thank you for attending. Without objection, adjourned.
Yeah. No, I mean, I wanted to hear what you.
Hey, Jackson.
Okay.
What's that, baby?